Have you ever thought about a constitution? I mean, really thought about what it is. Is it just a rule book, fist forever the day it's written?
Hmm.
Or is it something more dynamic, something that can, adapt and change as society does?
Right, a living document, as they say.
Exactly. But then, how much change is okay?
Yeah.
When does adapting cross the line and become, well, something else entirely? Something that maybe loses the original spirit?
That's the fundamental tension, isn't it?
It really is. And today we're doing a deep dive into exactly that through one of the most fascinating legal ideas in India, the basic structure doctrine.
Ah, yes. A truly unique concept.
It really is. It's all about what makes the Indian Constitution fundamentally Indian.
Mhm.
What are those core elements that supposedly can never be changed,
Hmm.
not even by Parliament?
Even with its amending power.
Right. So our mission today, we're going to navigate through some landmark court cases, some big parliamentary moves. Think of it like a high-stakes legal chess game played out over decades.
That's a great analogy.
And hopefully we'll get to those aha moments, making this complex stuff feel a bit clearer and show why it matters to, well, everyone.
And it's crucial to remember this basic structure idea. You won't find those exact words in the original Constitution text.
Oh, interesting. So it wasn't there from day one.
No, not explicitly. It's a judicial innovation. It grew out of this intense debate, really, about Parliament's power versus the Constitution's core principles.
So a power struggle.
At its heart, yes, Parliament wanting to amend, adapt, legislate for a changing nation, and the judiciary stepping in saying, hold on, some things are too fundamental to change.
Protecting its essence.
Exactly, protecting the fundamental ethos.
Right.
We'll see how the Supreme Court kind of carved out this protected space for the Constitution's core identity.
Okay, so let's start right at the beginning. India's constitution comes into force, 1950. New nation, huge challenges, land reform being a big one.
Absolutely critical at the time.
And almost immediately, this question pops up. Can Parliament actually change the fundamental rights guaranteed to citizens? What was the initial vibe, the first understanding of Parliament's power here?
Well, initially, the pendulum swung very much towards Parliament. The early view was quite clear.
Okay.
Almost right away, challenges arose concerning these fundamental rights, the core liberties in Part 3 of the Constitution. And this bumps up against two key articles.
Okay.
You got Article 13, which basically says any law that clashes with fundamental rights is void. Think of it as a shield for those rights.
The shield.
And then there's Article 368, which lays out the actual process for Parliament to amend the Constitution itself.
The amending tool.
Precisely. So the first big test case was Shankari Prasad versus Union of India way back in 1951.
Wow, just 1 year in.
Yes. The challenge was against the First Amendment Act. This amendment, it curtailed the right to property, which was a fundamental right then, and it added land reform laws to something called the Ninth Schedule.
The Ninth Schedule, what's that?
It's like a protective box. Laws put in the Ninth Schedule were basically shielded from being challenged in court on the grounds that they violated fundamental rights. Parliament saw this as necessary for pushing through crucial social reforms.
I see. So protect the reforms from legal challenges.
Exactly. Now, in Shankari Prasad, the Supreme Court ruled that, yes, Parliament does have the power under Article 368 to amend the Constitution. And crucially, this power includes amending fundamental rights.
So no special protection for fundamental rights from amendments.
Not according to this ruling. The court made a key distinction. It said the word law in Article 13, the shield, only refers to ordinary laws made by Parliament day to day.
Okay.
It did not, in their view, include constitutional amendment acts. Those were seen as something different, an exercise of Parliament's fundamental power to shape the nation's core law, what they called constituent laws.
So amendments were like a higher form of law.
In a sense, yes. Above the reach of Article 13's shield. This meant Parliament could trim or even remove a fundamental right through an amendment, and Article 13 wouldn't invalidate it.
That sounds like enormous power for Parliament.
It was, and this view was confirmed again in 1964 in the Sajjan Singh versus State of Rajasthan case.
Okay, so Shankari Prasad and then Sajjan Singh.
Right. So for over a decade, the consensus was pretty solid. Parliament's amending power was supreme, even over fundamental rights. No clear limits seemed to exist.
Wow. So Parliament really held all the cards, constitutionally speaking, in those early years. It could change pretty much anything, including the basic rights.
That was the prevailing legal view, yes.
But you mentioned a turning point, Things didn't stay that way, did they?
Yeah.
This is where the legal chess match, as you said, gets really interesting.
Absolutely. The ground shifted dramatically in 1967 with the Golak Nath versus State of Punjab case. This was a huge moment.
Golak Nath. Okay. What was the context here? Still land reform?
Yes, fundamentally. The challenge was, again, related to land reform acts being placed in that protective Ninth Schedule, this time via the 17th Amendment Act of 1964. Same pattern, different case.
But a different outcome this time.
A completely different outcome. The Supreme Court in Golak Nath did a full 180-degree turn. It directly reversed its earlier rulings in Shankari Prasad and Sajjan Singh.
A reversal. How so?
By a narrow majority, 6 judges to 5, the court declared something quite profound. It said fundamental rights aren't just important, they hold a transcendental and immutable position.
Transcendental and immutable. What does that mean in plain English?
It means they were seen as being above the ordinary political process, almost sacred. So fundamental, so unchangeable, that Parliament simply could not shorten or take away any of these rights. Full stop.
Wow. So completely off limits to Parliament's amending power.
That was the declaration. They were seen as essential to India's identity as a democratic republic, defining what it meant to be a citizen.
What was the legal reasoning for such a dramatic shift? How did they justify overturning their own previous rulings?
The key was a new interpretation of that word law in Article 13. Remember how Shankari Prasad said law meant only ordinary laws, not amendments?
Right. Amendments were special.
Well, Golak Nath flipped that. The court now held that a constitutional amendment is also a law under Article 13.
So amendments are subject to the shield, too.
Exactly. Therefore, if a constitutional amendment violated or took away a fundamental right, Article 13 would kick in and make that amendment void.
That is a seismic shift. It completely rebalances the power.
Immense. It significantly clicked Parliament's wings regarding fundamental rights, placing them beyond the reach of amendment. It effectively created an untouchable core within the Constitution, at least concerning these rights.
So from Parliament can do anything to Parliament can't touch these rights at all. That's a huge swing. You mentioned the land reform context earlier, so Parliament's trying to push social reforms.
Which often involved property rights, yes.
And the court suddenly says, hands off these fundamental rights entirely. How did Parliament, which clearly thought it was supreme, react to this? This judicial assertiveness must have caused fireworks.
Oh, absolutely. Parliament's reaction was swift, direct, and unambiguous. They saw Golak Nath as a major challenge to their legislative authority.
What did they do?
They enacted the 24th Amendment Act in 1971. This wasn't just a routine amendment. It was a direct legislative counterpunch aimed squarely at nullifying the Golak Nath judgment.
Trying to undo the court's ruling through legislation.
Precisely. The 24th Amendment specifically targeted those 2 key articles again, Article 13, the shield, and Article 368, the amending tool.
Okay, how did it change them?
It amended Article 368 to explicitly state that Parliament does have the power to take away or shorten any fundamental right. And crucially, it added a clause saying that an act amending the Constitution will not be considered a law for the purposes of Article 13.
Basically writing the Shankari Prasad interpretation directly into the Constitution.
Exactly that. It was Parliament trying to codify its own supremacy, directly overriding the Supreme Court's interpretation in Golak Nath. A clear message. We have this power, and we're putting it in writing.
A definite power play, setting this stage for the next round.
Yeah.
So Parliament fires back, amends the Constitution itself to say, yes, we absolutely do have the power to amend fundamental rights, and the courts can't use Article 13 to stop us. This feels like it's escalating towards a major constitutional crisis, a direct showdown.
It really was. This legislative countermove set the stage perfectly for what is arguably the single most important case in Indian constitutional history. Kesavananda Bharati versus State of Kerala, decided in 1973.
Kesavananda Bharati, I've heard that name. This is the big one.
This is the Mount Everest of Indian constitutional law. The stakes were incredibly high. The case wasn't just about the validity of the 24th Amendment Parliament had just passed.
No. What else?
It became the ultimate battleground for defining the very nature and, critically, the limits of Parliament's power to amend the Constitution. The core question before an unprecedented 13-judge bench, the largest ever in India.
13 judges, wow.
Yes, reflecting the immense gravity. The question was, is Parliament's amending power under Article 368 absolute? Or are there some inherent, perhaps unwritten, limits?
The ultimate question about power and limits.
Precisely. And the judgment they delivered was incredibly complex, deeply divided, but ultimately a landmark piece of judicial statecraft. It tried to find a middle path.
Okay, break it down for us. What did they decide?
Well, on one hand, the court, by a wafer-thin 7-6 majority, overruled its own previous decision in Golak Neth.
Overruled Golak Neth. So they went back on the transcendental and immutable rights idea.
In a way, yes. By overruling Golak Neth, they upheld the validity of that 24th Amendment Act Parliament had passed.
The one that said Parliament could amend fundamental rights.
Exactly. So this part of the ruling seemed like a victory for Parliament. It affirmed that Parliament is empowered to amend, even abridge, or take away fundamental rights.
Okay, so Parliament gets its power back, seemingly.
Seemingly. But, and this is the revolutionary but, the core of the decision, at the very same time, the court introduced this completely new doctrine, the doctrine of the basic structure or basic features of the Constitution.
Here it is, the basic structure. What did that mean?
It meant that while Parliament's power to amend under Article 368 is wide, it's not unlimited. It does not allow Parliament to alter, damage, or destroy the fundamental pillars, the core identity, the basic structure of the Constitution.
So you can renovate the house, but you can't knock down the load-bearing walls.
That's a perfect analogy. You can amend, but you can't destroy its essential nature. Parliament could amend a fundamental right.
Right. Yes, unless doing so would damage or destroy a feature that forms part of this basic structure.
That sounds like an incredible balancing act. How did they come up with that? It was a brilliant judicial innovation. It acknowledged Parliament's need to amend the Constitution to keep it relevant, preventing it from becoming too rigid.
Which is important.
Very. But it simultaneously placed a substantive check on that power, ensuring the Constitution's core values, democracy, secularism, federalism, the rule of law remained protected, sacrosanct. It established a kind of constitutional bedrock.
Wow. So, amendable but not destructible. What was the immediate fallout? Did this new basic structure doctrine actually get used right away, or did it just sit there as theory for a while?
Oh, it was put to the test almost immediately and in a very high-profile, politically charged case, too.
Which one?
The Indira Nehru Gandhi versus Raj Narain case in 1975, often just called the election case. This really showed the doctrine wasn't just academic, it had real teeth.
The election case. What happened there?
Well, the context is vital. Prime Minister Indira Gandhi's election had been invalidated by the Allahabad High Court on grounds of electoral malpractice.
A sitting prime minister's election invalidated. Huge news.
Absolutely. In response, Parliament, during the period of the national emergency, a time when democratic norms were suspended,
Right. A very controversial period.
passed the 39th Amendment Act.
Yeah.
This amendment did something quite extraordinary. It basically said that election disputes involving the Prime Minister and the Speaker couldn't be reviewed by any court. It tried to place them above judicial scrutiny.
Creating a special, unchallengeable status.
Exactly. And it even applied retrospectively to validate the PM's election.
So how did the Supreme Court respond using this new doctrine?
They struck down that specific provision of the 39th Amendment. They ruled it was beyond Parliament's amending power because it damaged the basic structure of the Constitution.
And what part of the basic structure did it damage?
The court reasoned that things like free and fair elections, which are the bedrock of democracy, and judicial review, the power of courts to examine laws, were essential features. Taking election disputes of key figures out of the court's hands violated these fundamental principles.
So the doctrine was immediately applied to protect democracy and the role of the courts.
Precisely. It showed the doctor was a powerful tool to check potential overreach, even during a time of immense executive power like the emergency. The judiciary asserted its role as the ultimate guardian.
Okay, so the court creates this basic structure idea in Kesavananda Faradi, and then uses it almost instantly in the election case to strike down a major amendment passed during the emergency. Parliament must have been furious. This sounds like the back and forth was far from over.
You're absolutely right. The election case ruling applying the basic structure doctrine so decisively was seen as a direct affront by the government of the day. Parliament wasn't ready to let the judiciary have the last word.
What was their next move in this constitutional chess match?
Their response was the 42nd Amendment Act, passed in 1976, still during the emergency. This wasn't just a minor tweak, it was a massive overhaul of the Constitution, so extensive it's often called the mini-Constitution.
A mini-constitution.
Because it made sweeping changes across many parts of the Constitution, largely aimed at increasing executive power and diminishing judicial oversight. But critically for our discussion, it directly targeted the basic structure doctrine.
How did it target the doctrine?
It amended Article 368 yet again. This time, it inserted clauses explicitly stating that there was no limitation whatsoever on Parliament's power to amend the Constitution. None.
No limits at all, trying to make the power absolute.
Absolute, absolute. And it went even further. It added another clause saying that no constitutional amendment could be questioned in any court on any ground.
Wow. Basically saying, our amendments are final, courts stay out.
Precisely. It was a direct attempt to legislate the basic structure doctrine out of existence and eliminate judicial review over constitutional amendments entirely. Parliament was trying to slam the door shut on judicial oversight of its amending power.
That's incredibly bold. We define the rules. End of story. How did the Supreme Court react to this? This was a direct challenge to its authority and the very doctrine it had painstakingly developed in Kesavananda Bharati.
It was indeed another epic confrontation waiting to happen. And it came in the Minerva Mills versus Union of India case, decided in 1980 after the emergency had ended and democratic processes were restored.
Minerva Mills, another landmark name.
Definitely. This case became the judiciary's definitive answer to the 42nd Amendment's challenge.
What did the court say?
It struck down those key provisions of the 42nd Amendment, the ones that claimed unlimited amending power for Parliament and excluded judicial review.
So the court pushed back hard. On what grounds?
The court declared unequivocally that judicial review is itself a basic feature of the Constitution. Taking it away, as the 42nd Amendment tried to do, would destroy the Constitution's fundamental structure of checks and balances.
So judicial review is part of the unchangeable core.
Exactly. Without it, the court argued, the Constitution would cease to be supreme because Parliament could change it however it liked with no check.
Makes sense. What about the claim of unlimited amending power?
The court tackled that head-on, too, using the basic structure doctrine itself. It laid down a really crucial principle, quite elegantly, actually.
What was the principle?
They said, essentially, that Parliament was given a limited power to amend the Constitution by the Constitution itself. It couldn't use that limited power to magically transform it into an unlimited power.
Like you can't use the key to the house to change the lock, so only you have the key.
Something like that. The court stated, since the Constitution had conferred a limited amending power on the Parliament cannot, under the exercise of that limited power, enlarge that very power into an absolute power.
You can't pull yourself up by your own bootstraps in that way.
Precisely. They added, a limited amending power is one of the basic features of the Constitution, and therefore the limitations on that power cannot be destroyed. Simply put, the done of a limited power cannot, by the exercise of that power, convert the limited power into an unlimited one.
That's powerful. It establishes limits as a fundamental feature.
It was a monumental affirmation. It cemented the basic structure doctrine, confirmed Parliament's power is not absolute, and firmly established judicial review over amendments. The court also mentioned the harmony and balance between fundamental rights and directive principles as a basic feature in this case.
So Minerva Mills really solidified the doctrine's place.
Absolutely. It effectively ended Parliament's most direct attempts to claim unlimited amending authority. The judiciary had successfully defended the core structure.
Okay, so the major battles seemed to be over by 1980. But you mentioned Kesavananda Bharati was decided in 1973. Was there any confusion about whether this basic structure doctrine applied to amendments made before that 1973 decision?
That's a very practical point, and yes, it needed clarification to avoid chaos. The Supreme Court addressed this in another case decided around the same time, Waman Rao versus Union of India, also in 1980.
Waman Rao, what did it clarify?
It firmly upheld the basic structure doctrine following Kesavananda and Minerva Mills, but the key clarification was about the timeline. The court ruled that the basic structure doctrine would only apply to constitutional amendments enacted after April 24, 1973.
Why that specific date?
That's the date the Kesavananda Bharati judgment itself was delivered.
So the doctrine applies prospectively from the day it was born, essentially.
Exactly. It meant that amendments passed before that date were generally safe from challenge under this specific doctrine, even if they might have touched upon things later identified as basic features. This provided crucial legal certainty and prevented the reopening of decades of constitutional history.
Right. That makes sense for stability. You can't keep relitigating the past indefinitely. Okay, so we've traced this incredible journey. Parliament can amend, but it can't touch the basic structure. The judiciary has defended this line, even striking down amendments. But the big question remains, what is this basic structure? Did the Supreme Court ever just issue a definitive list like, here are the 10 unchangeable things?
Wouldn't that be convenient? But no, it hasn't quite worked like that. The current position is clear. Parliament can amend anything, including fundamental rights, unless it affects the basic structure.
Right.
However, the Supreme Court has deliberately not provided an exhaustive, closed list of what constitutes the basic
A
structure.
final checklist. Why not?
Well, the thinking seems to be that providing a fixed list might make the doctrine too rigid. Society evolves, new challenges arise, and perhaps new understandings of what is truly fundamental might emerge. Keeping it somewhat open allows the court to respond to future situations.
This is more of an evolving concept.
Exactly. It's been identified piece by piece, case by case, as different aspects of the Constitution have been challenged through amendments. The court looks at the amendment and asks, does this particular change damage something absolutely fundamental to the Constitution's identity?
That's interesting. Flexible, but maybe also a bit uncertain.
That's the criticism sometimes leveled, that it gives the judiciary significant power to define these limits as it goes. But the counter-argument is that it's necessary to protect core values from unforeseen threats.
Okay, so if it's not a fixed list, how do we get a handle on what has been considered part of the basic structure? Can you give us some examples from the key judgments we discussed and others? Maybe group them so we can see the patterns?
Absolutely. We can definitely outline the key elements that have emerged over time from various rulings. Think of them as the pillars identified so far.
Great. Let's hear some.
Okay, first, there are principles about the fundamental nature of the Indian state. Supremacy of the Constitution. This came right out of Kesavananda Pharati. The Constitution is the top dog, the supreme law. Everything else is below it.
The ultimate rule book.
Sovereign, democratic, republican nature. Also, Kesavananda. India governs itself, power comes from the people, and the head of state is elected. Core political identity.
Non-negotiables for India's character.
Secular character. Again, Kesavananda, and later cases like S.R. Bomai. No state religion, equal respect for all faiths. Hugely important in a diverse country.
Crucial for unity.
Federal character. Kesavananda Bomai. The division of powers between the center and the states. Acknowledges regional diversity.
Power sharing.
Unity and integrity of the nation. Kesavananda. Keeping India together as one nation.
Foundational.
Welfare state. Socioeconomic justice. Mentioned in Kesavananda, the commitment to upliftment and social justice for all citizens.
So the state has a purpose beyond just governing.
Yes, a positive obligation towards its people's well-being.
Okay, that covers the state's identity. What about the machinery of government itself, how it's structured and how it works?
Good question. Several features relate to the governance framework. Separation of powers, Kesavananda. Keeping the legislature, executive, and judiciary distinct, with checks and balances between them, prevents concentration of power.
Classic checks and balances.
Parliamentary system, Kesavananda. The executive government being responsible to the legislature, parliament. How India's democracy functions at the top.
Accountability to the elected body.
Rule of law. Came up strongly in the Indira Gandhi election case. Everyone, including the government, is under the law, not above it. No arbitrary power.
Foundational for any democracy.
Limited power of Parliament to amend. This was the big one from Minerva Mills. The fact that Parliament's power is limited is itself a basic feature. They can't grant themselves unlimited power.
The limit itself is fundamental. That's quite meta.
It is. It protects the whole structure.
Right. State identity, government structure. Yeah. What about the citizen? The rights and protections.
Yes. Arguably the most crucial area for individuals. Rights and judicial protection. Judicial review. Hugely important. Indira Gandhi case, Minerva Mills, and many others. The power of courts to review laws and government actions to ensure they are constitutional. Without this, the basic structure doctrine is just words.
The courts as guardians.
Freedom and dignity of the individual. Kesavananda. Protecting basic human rights and inherent worth.
Core human values.
Harmony and balance between fundamental rights and directive principles. From Minerva Mills. Neither set of principles can completely override the other. They need to work together.
Finding that balance.
Principle of equality. Indira Gandhi case, Indrasani. Equal treatment and non-discrimination. Absolutely fundamental.
Bedrock principle.
Free and fair elections. Also the Indira Gandhi case. Essential for democratic legitimacy.
Can't have democracy without it.
Independence of judiciary. Mentioned in Indrasani. Courts need to be free from pressure to uphold the rule of law impartially.
Crucial for fairness.
Effective access to justice. Making sure people can actually use the legal system to protect their rights.
Justice can't just be theoretical.
And then specific powers of the Supreme Court and High Courts, like under Articles 32, 136, 141, 142 for the Supreme Court, and 226, 227 for High Courts. have also been recognized as basic features in various cases because these powers are the tools the judiciary uses to protect rights and uphold the Constitution.
So even the specific tools of the judiciary are protected.
Yes, because they are essential for the judiciary to perform its constitutional role.
That's quite a comprehensive list, even if it's not exhaustive. Seeing them laid out like that really helps paint a picture of what the courts consider the unshakable foundations. It's truly fascinating how this picture has been built up case by case, debate by debate, over decades. Not a sudden blueprint, but something forged in conflict. Tag outro. So where does this leave us? We've taken quite a journey, haven't we? From the early days where Parliament seemed all-powerful, able to change anything,
A wide open field, seemingly.
to the emergence of this profound basic structure doctrine, drawing lines that even Parliament cannot cross. It's a story of judicial courage, political conflict, and the deep question of how a constitution stays true to itself while still adapting.
And thinking about the bigger picture, this doctrine really serves as a vital check against what you might call constitutional capture by a temporary majority. Meaning it prevents a government, even one with a huge mandate, from fundamentally altering the core democratic, secular, or federal nature of India just because it has the numbers in parliament at that moment.
Right. It protects the long-term identity from short-term political wins.
Exactly. It safeguards the spirit, the underlying values of the Constitution, things like democracy, individual dignity, judicial review, ensuring those promises hold firm. It really underscores the vital, sometimes uncomfortable role the judiciary plays in a democracy as the guardian of that constitutional core.
It really does. And that brings us to a question for you, our listener. Thinking about this delicate, sometimes tense balance between Parliament's power to change things and the judiciary's power to protect the core.
Right.
How do you see the basic structure doctrine fitting into the resilience of democracy, especially in a world that's always changing? What aspect of this whole legal saga stands out most to you?
And maybe also ponder this. Could India's experience with this evolving idea of an unamendable core offer lessons or perhaps warnings for other countries trying to navigate that same difficult balance between constitutional flexibility and protecting fundamental principles? It's certainly a unique contribution to global constitutional thought.
Absolutely. Well, thank you for joining us on this deep dive into the basic structure doctrine. We hope it's given you not just some legal knowledge, but maybe a deeper appreciation for that constant, complex interplay between power and principle that shapes the very foundation of a nation.